If you or someone you love has filed an I-130 family petition or is planning to file one, you may have heard something about a priority change coming in February 2026, and you might be feeling confused, anxious, or even panicked about what this means for your case. Let me be very clear with you right from the start. There is a lot of noise online, a lot of half-truths being shared on social media, and some people are spreading fear without giving you the full picture. That stops right here, right now. My name is Saqib, and you are watching Global Immigration Updates, where we bring you fact-based immigration news without the rumors, without the panic, and without the politics. Our goal is simple. We want to help you understand what is actually happening, so you can make informed decisions about your immigration journey. Today, we are going to talk about the I-130 priority change that is being discussed for February 2026. We are going to break down what it is, who it affects, what it does not affect, and most importantly, what you should do about it. Before we dive into the details, let me say this. Immigration policies and processing procedures do not change overnight. There are systems in place, there are regulations, and there is a process for any major change. So if you have been losing sleep over a headline you saw on Facebook or a video that scared you on TikTok, take a breath. We are going to walk through this step by step, and by the end of this video, you will have clarity. So what exactly is this I-130 priority change that people are talking about? Let me start by explaining what the I-130 petition is, because not everyone watching may be familiar with the term. The I-130, officially called the Petition for Alien Relative, is the form that United States citizens and lawful permanent residents, also known as green card holders, file with USCIS to sponsor certain family members for immigration to the United States. This is the first step in the family-based immigration process. When you file an I-130, you are essentially establishing the relationship between yourself and your family member and starting the process that could eventually lead to them receiving a green card. Now, once USCIS approves your I-130 petition, what happens next depends on a few things. It depends on your relationship to the person you are sponsoring, it depends on whether you are a U.S. citizen or a green card holder, and it depends on the country your family member is from. Some family relationships are considered immediate relatives, such as spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens. For these immediate relatives, there is no waiting list. Once the I-130 is approved, they can move forward with their green card application relatively quickly. But for other family relationships, there are annual limits on how many visas can be issued, and this creates what is known as the visa bulletin and priority dates. If you are sponsoring a sibling, an adult married child, or if you are a green card holder sponsoring a spouse or child, your family member will need to wait until their priority date becomes current before they can proceed with their green card application. The priority date is usually the date that USCIS receives your I-130 petition. So what is changing in February 2026? Here is what we know based on information that has been circulating and discussions happening within immigration circles. There are reports that USCIS may adjust the way it prioritizes or processes certain I-130 petitions starting in February 2026. Now, let me be extremely clear. As of the time I am recording this video, USCIS has not issued an official policy memo or public announcement detailing exactly what this priority change will look like. This is important. What we are seeing right now are mostly leaks, discussions, and preparatory notices, but not a final rule. From what is being discussed, the change may involve adjustments to processing times, changes in how cases are queued for review, or potentially shifting resources to prioritize certain categories of family petitions over others. Some sources suggest that USCIS may focus more heavily on clearing backlogs for immediate relative petitions or may reorganize how family preference categories are handled. There is also talk about whether USCIS might implement changes to how it assigns priority dates or manages the inventory of pending cases. Here is the key point. These kinds of administrative changes happen periodically. USCIS is constantly looking for ways to improve efficiency, reduce backlogs, and streamline processing. That does not necessarily mean that your petition is in danger, that your case will be delayed, or that the rules are being rewritten to your disadvantage. What it usually means is that USCIS is reorganizing internally to handle the volume of cases it receives. Now let me address some of the rumors and misunderstandings that are spreading online, because this is where a lot of the fear is coming from. Rumor number 1. The I-130 process is being canceled or shut down. This is completely false. The I-130 petition is a foundational part of the U.S. immigration system. It is established by law, specifically the Immigration and Nationality Act. USCIS cannot simply cancel it. Any major change to family-based immigration would require an act of Congress, not just an administrative decision by USCIS. Rumor number 2. All pending I-130 petitions will be rejected or need to be refiled. Also false. If you have already filed an I-130 and it is pending, it remains pending. Administrative changes to processing priorities do not invalidate petitions that are already in the system. Your petition will continue to be processed. What might change is the order in which cases are reviewed or how quickly certain categories move, but your petition does not disappear. Rumor number 3. Only people who file after February 2026 will benefit from the new system. This is misleading. If USCIS implements changes that improve processing efficiency, those changes could benefit both new and pending cases. Conversely, if the change involves reallocating resources, it might affect different categories in different ways. The point is, we do not yet have enough official information to say definitively who will benefit and who might see longer wait times. That is why it is so important to wait for the official announcement rather than assuming the worst. Rumor number 4. This change is political and targeted at certain countries or groups. There is no evidence to support this. Administrative changes at USCIS are typically about efficiency, resource allocation, and managing workload. They are not about targeting specific nationalities or discriminating against particular groups. If any policy change were to have a discriminatory effect, it would be subject to legal challenge and public scrutiny. So who is actually affected by this potential priority change? The honest answer is that until USCIS releases the official details, we cannot say with certainty. However, based on the discussions and the context, it is likely that any changes will primarily affect how USCIS internally manages its caseload. This could mean that some categories of family petitions are processed faster, while others might experience slightly longer waits. It could also mean adjustments to how cases are assigned to officers or how backlogs are addressed. If you have already filed an I-130, your case remains in the system. If your I-130 has already been approved and you are waiting for your priority date to become current, that waiting period is governed by the Visa Bulletin, which is managed by the State Department, not USCIS. Changes at USCIS regarding I-130 processing would not directly change your priority date or your place in line for a visa number. If you are planning to file an I-130 soon, it is worth keeping an eye on any official updates from USCIS, but there is no reason to panic or rush to file unless you are already planning to do so. Filing a petition before you are ready or before you have all your documents in order can cause more problems than waiting a few weeks for clarity. Now let me talk about what you should actually do. First, stay informed by checking official sources. The best place to get accurate information is directly from USCIS. You can visit uscis.gov, sign up for email updates, and check their news and policy sections regularly. USCIS typically announces major changes through official policy memos, Federal Register notices, or press releases. Do not rely solely on social media, YouTube videos, or secondhand information. Second, if you have a pending I-130, monitor your case status online through the USCIS Case Status tool. If there are any updates or requests for evidence, you will be notified. If your address has changed, make sure to update it with USCIS using Form AR11 so you do not miss any important notices. Third, if you are working with an immigration attorney, reach out to them and ask if they have received any official guidance about the February 2026 changes. A qualified attorney will have access to AILA, the American Immigration Lawyers Association, which often provides detailed analysis and updates on policy changes. Fourth, be patient and do not make drastic decisions based on incomplete information. Immigration is a long process, and it requires patience. Making hasty decisions, such as withdrawing a petition, filing duplicate petitions, or trying to switch to a different immigration pathway without proper legal advice can cause serious problems down the line. Fifth, if you are planning to file an I-130 and you have all your documents ready, there is generally no harm in moving forward. Filing sooner rather than later can establish your priority date, which is important for preference categories. However, if you are not ready, do not rush. Take the time to gather accurate and complete documentation. Let me also remind you that immigration processing is governed by law and regulation. Changes to processing procedures, even if they affect wait times or case handling, do not happen in a vacuum. USCIS operates under the framework of the Immigration and Nationality Act, and any significant policy shift must go through a formal process, often including public comment periods and legal review. This means that even if a change is coming, there will be transparency, there will be guidance, and there will be time to understand and adapt. I also want to reassure you that the immigration system, while complex and often frustrating, is designed to process cases fairly and according to established rules. Delays, backlogs, and procedural changes are frustrating, but they are not the same as denial or rejection. Your case is still your case. Your relationship is still your relationship, and the law still provides a path for family reunification. One more thing I want to emphasize. If you are feeling overwhelmed or uncertain about your specific situation, it is okay to seek help. A qualified immigration attorney can review your case, explain how any policy changes might affect you, and help you make informed decisions. There are also nonprofit organizations and legal aid clinics that offer free or low-cost immigration assistance. Do not suffer in silence, and do not make important decisions based on fear. Before I wrap up, I want to remind you that immigration news can be confusing, and it can be scary, especially when you have loved ones waiting, or when your future depends on the outcome of a petition. But panicking does not help. Misinformation does not help. What helps is staying informed, relying on trusted sources, and taking thoughtful, measured steps. That is exactly why we created Global Immigration Updates. We are here to cut through the noise, to bring you the facts, and to help you navigate the immigration system with confidence and clarity. If you found this video helpful, please subscribe to this channel and turn on notifications so you do not miss any future updates. Immigration policies change, processing times fluctuate, and new announcements come out regularly. We will be here to break it all down for you in simple, clear language. If you know someone who is worried about the I-130 priority change or who has a family petition pending, please share this video with them. Knowledge reduces fear, and accurate information empowers people to make the right decisions. And finally, I want to hear from you. If you have questions about the I-130 process, about family-based immigration, or about any immigration topic, leave a comment below. I read the comments, and I do my best to respond or to create videos that address the questions you have. Your input helps shape the content we create, and it helps build a community of people who support each other through the immigration journey. Thank you for watching. Stay calm, stay informed, and remember, immigration is a process, not a race. We will get through this together.